Okay. All right, thank you. Welcome to the third in a series of excellent webinars that we've had this summer. This one is on the session will be called Free Speech and Minorities. And I've been very deeply honored to have Oscar Pérez de la Fuente organize these. He's got very creative ideas, and it's a wonderful way of getting together during the summer and to talk about ideas. I've only had a chance to quickly skim and read a bit through David Hahn's and Bill Araiza's papers, but I found them both fascinating and on very current issues which were critical. Why don't we do it in alphabetical order? And I'm hoping that Professor Tatiana Barandova will join us, but she is not with us. I'll introduce her.
She's joining now, Alex.
She's joining now. Okay. Oh, let me hold on then.
In the process of joining, sorry.
Maybe, well,
Oops, she
I'll
fell
just
off.
say, okay. So first, Professor Araiza will speak about government speech and minority rights. If Professor Tatiana Barandova does join us, she will then speak about representation of migrants' rights in visual, verbal, and official discourse in the context of COVID-19 period in Russia. And Professor David Hahn will discuss disentangling the cancel culture. Professor Araiza is joining us from the Brooklyn School of Law, where he is a professor. Tatiana Barandova from Russian Academy of National Economic and Public Administration. And Professor David Hahn is joining us from Pepperdine University, Caruso School of Law. And so with that, if each of you could take 15 minutes, and then we'll also have a discussant who will comment after you've completed your comments. Thank you.
Great. Okay. Good afternoon. Buenas tardes. I'm assuming that everyone, hoping everyone can see my PowerPoints. Alex, can you jump in and confirm that you can see my PowerPoints?
Yes, thank you so much
Yes?
for checking. Yes, I can.
Thank you. Okay. So I'm so pleased to be on this panel. My thanks to Oscar for organizing.
Bill, just before you start, we can also see what's on the left. So if you don't want us to see that, then block that out.
Oh, well, those are, yeah, I'm not so good at PowerPoint that I can figure out how to do that. So I don't want to take the time. You'll just get you'll get a preview of the slides that are coming up. At any rate, my thanks to Oscar for organizing the event and for Alex for moderating the panel. My topic is government speech and minorities. We all, of course, know the long and awful history of group-oriented violence in the 20th century. Obviously, we have the example of Rwanda, but obviously, just as obviously, well before and well after the Rwandan genocide, there has been a long history in the 20th and sadly 21st century of ethnic, religious, and racial violence across the world. From the Holocaust to Rwanda and everything between and since, government propaganda has usually preceded the actual physical horrors of genocide. On the other hand, a lot of government speech is not only benign, but is essential to government's legitimate regulatory authority. This, for example, is a US government poster urging people to quit smoking. Completely benign, completely appropriate. The comparison, obviously, to this sort of horrific propaganda is obvious. The difficult question is disentangling them, both as a practical but also as a legal matter. The basic question then is how to distinguish between harmful and beneficial government speech. And in this talk, I'm going to be focusing on 4 examples of the kind of government speech that might in fact disparage minorities. First of all, so-called no promo homo laws, that is to say, laws that prohibit public school teachers from describing homosexuality or bisexuality as an acceptable lifestyle. So no promotion of homosexual laws, hence no promo homo. Second of all, statements of the society's or the polity's Christian identity. This is obviously private speech, this billboard, but if government were to do the same thing and say, for example, America is a Christian nation, clearly that disparages non-Christians of all sorts. Third of all, this is the sort of most famous example, at least in the United States, the official display of the Confederate flag. And finally, maybe a little bit more tenuously in terms of speech, substantive regulation, for example, the prohibition on gender-affirming surgery. All of these are examples that I'll be talking about in my discussion. So in the United States, a basic question about government speech, really the first question that has to be asked is whether the government, like private persons, has a First Amendment right to speak. Now, perhaps ironically or counterintuitively, a lot of scholars, I think quite correctly, have concluded that it would be highly problematic for the government to be thought of as having First Amendment rights. First of all, because under the First Amendment, private parties are free to speak in disparaging ways if they wish. If the government had that same First Amendment right, then we would be essentially allowing government to engage in disparaging speech of the sort that we're discussing today, and that would be a problem. The only way to get around it, if the government had a First Amendment right to speak, would be to distort First Amendment doctrine in a very serious way, in a very troubling way. Even more generally, the standard explanations for why there were free speech rights to begin with really don't fit with the concept of government having First Amendment rights. So the idea that government somehow self-actualizes when it speaks is not really coherent. Government is not a natural person. It is not even an association of persons who gather for speech purposes. The second justification, can government speech really contribute to self-government? Not only is that logically circular, but it raises the great concern that people who currently hold government power could use government power in order to retain that political authority. And that's in itself quite problematic. Finally, is there a possibility that government could contribute to the marketplace of ideas by speaking? Theoretically, that's true. On the other hand, government has such power that there is a real risk that government could in fact drown out the marketplace by essentially swamping it with its own speech. Okay, rejecting the government's First Amendment claim then really requires that we think about other justifications for government speech other than the First Amendment, and in turn limits on those justifications. So before we get to that discussion, we need to think about a couple of preliminary issues. First of all, is the government speaking at all? This brings us to what Americans will recognize as a classic case, the 1896 case of Plessy v. Ferguson, where Louisiana passed a law segregating trains based on race. And here we have Mr. Homer Plessy, or a representation of him in a rail car reserved for white people. Now, the reason that Plessy matters here is because in upholding the train segregation law, the majority, speaking through Justice Brown, explained that if the African American community viewed the train segregation law as suggesting their inferiority, that message was one that the African American community itself chose to place on the law rather than the message from the state. In other words, the state wasn't really communicating anything via the segregation law. Here's the key language. We consider the underlying fallacy in the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this is true, it's not because of anything in the law, but solely because that race chooses to put that interpretation of the law on it. So now, as scholars have recognized, the court's argument implicates the state action idea, by suggesting that whatever the state was doing, it was not communicating a message of inferiority. So, first question, is government speaking at all? Second question, assuming that the government is speaking, is a disparaging message by itself enough to justify finding a constitutional violation? That brings us to a 1971 case called Palmer v. Thompson. This was a case where a city in Mississippi, under a court order to integrate its swimming pools, decided simply to close the swimming pools down entirely. Now, that is absolutely, everyone thought that this was in response to the integration order, but the court says no equality violation because both blacks and whites are being harmed by the city's decision to close the pools down. In other words, any city purpose to prevent integration, to send a message of inferiority to the black community, we don't want to associate with you. Any message was by itself not adequate to violate equal protection without a differential material impact on the black plaintiffs. So let's assume, number one, the state really is saying something, and number two, that the more direct communication in our four hypothetical cases serves to distinguish the case from Palmer. It may or may not is a real matter, but let's assume that. But even before we get to the limits on government action to speak, we have two interrelated final preliminary issues to think about. Number one, what if the government merely approves of private conduct? For example, what if the government speaks in support not of its own discrimination, but of private parties' discrimination? Hypothesize, for example, with the no promo homo example I gave you, that rather than simply enacting a no promo homo public school curriculum, instead, the state merely endorses or recognizes the rights of religious or other private groups to consider homosexuality to be immoral. For Americans, this might sound familiar. This sounds a little bit like Reitman versus Mulkey. That was a 1967 case involving a situation where the state was accused of violating equal protection by endorsing private discriminatory acts. Consider then a state law that rather than instituting a no promo homo curriculum in the public schools, explicitly authorizes private schools to do that. Query whether that ends up looking just like Reitman, where the court actually finds an equal protection violation due to the state's endorsement of that private discrimination. Now, even this hypo needs to be complexified very briefly. What if the approved of private conduct is itself constitutionally protected? In the United States, as in other democracies, people have a right to believe as they wish in terms of religion. What if the state endorses people's constitutional rights to believe that, and to state that they believe homosexuality to be immoral? Query, does the constitutional protection given that belief or conduct, does that somehow make it okay for the state to endorse those private beliefs? All right. With these preliminary matters out of the way, we now need to think about the equal protection argument. It's a very intuitive one, the kind of speech that we've been talking about, disparaging speech, speech that harms or attacks minorities. We can easily see how that might offend the Equal Protection Clause, the provision that prevents government from denying any person the equal protection of the laws. As intuitive as that sounds, there are still obstacles to the government, to the equality argument. First of all, much government speech might be thought of as denigrating. This is government anti-obesity speech. Fighting obesity, a legitimate government interest. Nevertheless, query whether these kinds of images and these kinds of statements are disparaging. This is a statement about the so-called gay ban for donating blood based on 1980s concerns about HIV/AIDS. That potentially has a real negative impact on the social status of gays and lesbians. And so there are lots of ways in which government speech can, in fact, easily disparage. But there are problems with an equal protection attack on that kind of speech. 30 years ago, there were claims made in court that the display of the Confederate flag was in fact an equal protection violation. Those cases failed, and they failed for a very interesting reason. Courts said that the black plaintiffs may have been offended by the display of the flag, but they could not show that they were the only groups that were offended, because whites and other groups were also offended. There was no disparate impact on the African American plaintiffs, therefore no equal protection harm that a court could remedy. Of course, that sounds just like Palmer v. Thompson, the swimming pool closure case. So equal protection claims against this kind of speech runs into some serious obstacles. So that raises a question about whether there's another way to attack the equality argument. And there may be. So I have done some writing on a doctrine called animus. Animus, to boil down a complex concept, is really simply a court conclusion that the government action in question is unsupported by any legitimate government interest. There's simply no legitimate reason for government doing what it's doing or saying what it's saying. And in turn, what that usually means in these cases is that courts conclude that the government action either is or must be motivated by an illegitimate government interest. Now, that sounds like a promising way of attacking the equal protection argument, because we don't have to worry so much about differential impacts. We simply ask whether the government has any legitimate reason at all for doing what it's doing. The nice thing about animus doctrine is that it steps into the breach, and it goes past to sort of mediating concepts like in Palmer v. Thompson to bore down to the core question: is government action supported by any legitimate government interest? Therefore, animus may well be a useful doctrine in attacking government speech that disparages. But it raises two interlocking issues that I want to spend just a couple of minutes in closing talking about. First of all, it raises the question on the x-axis of whether what's going on is pure expression by the government versus expression related to substantive regulation. And second, along the vertical axis, whether there's any legitimate government interest underlying that either expression or that regulation. That creates a grid with 4 boxes, and very briefly I want to talk about these 4 boxes and how they come out in terms of the doctrine. So box number 1, pure expression, no legitimate government interest. So pure expression, no legitimate government interest, box number 1. Essentially, expression that is unsupported by any legitimate government reason, which basically means government saying we just don't like you. In a lot of ways, that's the classic animus case. That's a relatively easy box. Box number 2, pure expression still, but in this case, there are legitimate government interests. So we're the lower left-hand box of this grid. That box is represented by the Confederate flag case. Pure expression, the flying of a flag, but at least some people will argue that there are legitimate government interests in government's desire to promote ideas of tradition or patriotism or local control or what have you. And that poses a really tricky question. Box number 2 requires us to consider whose perceptions count. The perceptions of those who see legitimate messages in the flag or those who see illegitimate messages. There is no neutral answer to this question or this clash. Rather, they inevitably depend on the relative weights one allots to the community's desire to express itself, and on the other hand, the weight we allot to the minority group's feelings of threat and exclusion. And that's a very tough question. Box number 3, we now move from pure expression to substantive regulation. But now, by hypothesis, regulation that has no legitimate government interest. So we're in box number 3, the right upper hand box, substantive regulation supported, however, by no legitimate government interest. One might see potentially gender-affirming surgery bans as an example of this. It's regulation, it sends a message, but maybe there's no legitimate interest underlying it. But I put a question mark next to the statement of no legitimate interest, because as American lawyers know, and probably most Europeans as well, courts are loath to second guess policy judgments about substantive regulations that are made through the democratic political process. And so box number 3 raises a difficult question of how much justification the court will insist on when that regulation is alleged to consist, at least in part, of disparaging speech. Finally, box number 4, expression again related to substantive regulation, but this time legitimate government interests exist. The lower right-hand box of this grid, substantive regulation supported in this case, however, by legitimate government interests. What's an example? Well, the quit smoking ad. This is obviously a part of a substantive program of tobacco regulation, but on the other hand, it's, and that's a legitimate interest. On the other hand, some of this kind of expression could in fact be disparaging. And what do we do in a case like that? It may well be that when we think about these hard cases, as well as, frankly, the Confederate cases with regard to pure expression, where there's a legitimate government interest, in those cases, we may well have to balance the interests of those who want to speak, or the interest, in the last case, of those who want to regulate in a particular way, versus the interests of those who feel threatened or excluded by the resulting expression. Different people say different things about this. People suggest, for example, that maybe we ought to be thinking about the social status of the excluded group. In American parlance, is this a suspect class? More generally speaking, is this a class that has suffered historically from marginalization and from attack? And finally, and this is the last thing I'll say, to what extent does the majority otherwise take account of those affected interests? Is there a way in which we can say this expression or this regulation may be okay, because at the end of the day, the Democratic majority nevertheless is speaking in a way that accounts for the interests of those private parties, those otherwise excluded groups. Okay? So my apologies if I went over, but thank you so much, and obviously I look forward to the discussion.
No, you were right on, Bill. That was exactly 15 minutes. So thank you so much. Let's go to Professor David Hahn next, and may I just ask, have we got everyone on? Is Tatiana Barandova, are you on? Tatiana Barandova, if you could yourself. I apologize, I can't see the whole list. Maybe someone else can.
Yeah, just
I see.
You're on. Okay, wonderful. Okay, thank you. So we'll go to you then third, and
yes.
I'm sorry, Alex, you cut out for a second, so I
was just going to say, David, if you could please speak
sure.
to us, and he's speaking to us about a really fascinating concept that is on the minds, particularly of those of us in the United States, but I think about the world, and I'm very much looking forward to listening to it. It'll be about disentangling cancel culture. Go ahead, David.
Well, thanks so much, Alex, and first of all, thanks so much to Oscar for organizing this really wonderful event. So what I want to talk today about is the so-called cancel culture debate, right? And so this is an issue that, particularly in the United States, has become a flashpoint within the present culture wars. And there are many aspects to this debate, but what I want to focus on is how it relates to broad principles regarding the freedom of speech. And as this debate has become highly polarized and politicized, it's been plagued by a lot of sort of messiness and imprecision. So in this project, I first want to sort of disentangle and clarify both the boundaries of the debate and its theoretical foundations. I'll then make a few observations regarding the debate, which is really at its heart a sort of ongoing social and cultural conversation regarding shared free speech values. So, in this age of the internet and social media, really this sort of collective deliberation regarding free speech norms is likely to shape the contours of public discourse to a far greater extent than formal legal doctrine. And so this project's still in its preliminary stages, and I really look forward to hearing everyone's thoughts on this. So as we all know, the debate regarding cancel culture has raged on over the past few years, particularly in the United States. So examples of both public and private figures being canceled sort of abound in American media, whether it's for past bad conduct or for making offensive or repugnant statements or for expressing socially unpopular views. But both the term itself, which is typically used in a negative sense, and its application to different contexts that's nebulous. It's all pretty nebulous. In the broadest sense, canceling in this context simply means social shaming and withdrawing support from people or companies in response to past transgressions. Now, if we look at it this broadly, cancel culture is really nothing new. Right? Social shaming for unpopular speech and actions has, of course, been around for time immemorial. And few will seriously argue that social shaming and ostracism can never be justified in any context. Right? So as one commentator put it, there's no human society where you can say or do anything you like and expect to keep your reputation and your job. Now, in a narrower sense, cancel culture might also refer to a particular type of social shaming. So one with features that are unique to the current age of the internet and social media. So what is it about the internet and social media that might make things so different? Well, first, our current technological context allows for a person's past sins to exist indefinitely. So in the pre-internet era, our past actions and statements were usually subject to, the vagaries of human memory and the limitations of physical documentation. But today, of course, we live in an era of digital receipts, right? Where, for example, one's long forgotten tweets from a decade ago may be indefinitely preserved. And as the common saying goes, the internet never forgets, at least in the United States. Second, social media also allows, of course, for the rapid and broad dissemination of social condemnation throughout the world, rather than the limited realm of, say, one's immediate social circle and community. So today, anyone with an internet connection can disseminate social condemnation instantaneously and without geographic boundaries. It doesn't depend on person-to-person interaction or discrete personal networks. So someone who's shamed can't simply move to a different village, right? The whole world is now a single village. Third, social media encourages the magnification of social shaming based really on how the platforms themselves operate, right? So social media companies broadly seek to maximize user engagement. So these are things like likes and retweets and comments. And engagement is in turn strongly driven by negative emotions like anger and outrage. All of this means that the sanctions that offenders suffer are likely to be more severe, like loss of employment. And the advent of social media has also magnified the severity of sanctions like deplatforming, like so removing people's access to speech platforms, and doxing, which is publicizing private information about somebody to exact punishment or revenge. And finally, the impersonality of the internet might create a sort of social and psychological distance that establishes a kind of otherness for the person being shamed. And this might differ from the pre-digital era where personal knowledge and sympathy might play a larger role. So on the one hand, cancel culture it's nothing new, right? As essence, it's the same sort of social shaming and ostracism that's always existed. On the other hand, this longstanding issue has taken on a new resonance given the unique social and technological context of today. Now, I want to pause here just to emphasize that the term cancel culture itself is not particularly helpful in analyzing this debate. Again, few will seriously argue that social shaming can never be justified under any circumstances. Again, as one commentator has put it, all cultures cancel. The question is for what, how widely, and through what means. So the term itself carries little analytical substance. In the current debate, it's typically used just as an empty epithet, right? It's a term that reflects the speaker's pre-existing disapproval rather than any meaningful analytical standard. So let's move on to the question of how free speech values play into both sides of this debate. And in doing this, I just want to highlight a great New York Times article written by Ligaya Bishan a few months ago that talks about some of these issues in more detail. So those opposing cancel culture, well, they primarily argue that imposing social sanctions on unpopular speech, like shaming or deplatforming or loss of employment, will ultimately chill those with unpopular opinions from speaking. So this might ultimately lead to groupthink and conformity within public opinion, a situation where people are increasingly afraid to articulate views that may not be socially acceptable, lest they suffer the consequences of cancellation. And furthermore, there might be a certain arbitrariness to the current incarnation of cancel culture. Who gets canceled often becomes a matter of happenstance. Some people are punished severely for relatively minor offenses, while similar or worse offenders may never be identified or affected in any way. So cancellation thus starts to resemble a chaotic sort of quasi-judicial process in which people are haphazardly selected for public punishment to serve as these sorts of examples for broad social ills. So they symbolically take on the role of the proverbial scapegoat. And among those that are selected for cancellation, the repercussions that they suffer can also be arbitrary. Some might lose their job and any future job prospects, while others might undergo, say, a short span of public disapproval that passes without consequence. So the formlessness of the canceling sanction might ultimately increase inequality. Maybe it's the wealthy and the privileged and the famous people who are canceled that can generally survive with little long-term repercussions, while non-public figures selected for cancellation are the ones that suffer substantial harm. Now, on the other side of the debate, to the extent that cancel culture simply refers to social shaming and criticism of a person's actions, this is, of course, nothing more than the normal exercise of the shamer's free speech rights, right? The ability to hold accountable those who hold reprehensible views. So just as people have the right to say what they please, people also have the right to criticize that speech through counter speech. And of course, freedom to speak doesn't include the right to be insulated against popular disapproval, which would be antithetical to free speech principles. And even if this disapproval came in the form of social ostracism or loss of employment, this is also consistent with free speech values. Just as we're free to criticize speech with which we disagree, we're also free to choose those with whom we will associate, which will often rest on that person's actions or opinions. So an extreme backlash against cancellation might risk just as much damage to free speech values as cancellation run amok. And this is evident within the context of the present cancel culture debate. Many of the recent cancellations have been rooted in social movements like Me Too and Black Lives Matter. And these are movements that are driven by the observation that important social issues have escaped notice for too long, and that recognition and correction of these social ills is sorely needed. So in this context, identifying and shaming offenders represents a form of long overdue accountability. Right? So it's giving voice to powerless victims who have been forced to bear their sufferings in silence, while imposing social sanctions on those who may have otherwise escaped any repercussions for their actions. So from this perspective, cancellation is the opposite of silencing, right? Rather, it's healthy criticism of existing social structures, right? It's these long-standing racial or gender-based hierarchies that have long evaded scrutiny. So accusations of cancel culture might be wielded merely as an empty epithet, by those seeking to silence these viewpoints within the marketplace of ideas, right? So it's an effort to entrench existing norms and power structures against social criticism and reform. So really, this is the core dilemma of the cancel culture debate, right? So on the one hand, criticisms of cancel culture might be warranted as severe social shaming can chill speech and effectively remove unacceptable viewpoints from public discourse. But on the other hand, what one side calls cancel culture might be deemed healthy social critique and commentary, a corrective to a historically imbalanced public discourse built upon long-standing racial or gender-based hierarchies. So I think there's an interesting parallel here between this debate and the long-standing debate within free speech theory regarding the operation of the marketplace of ideas, right? So each side of the cancel culture debate effectively adopts a different rhetorical mode. So those critical of cancel culture tend to adopt the rhetoric of speech, right? So, we can't chill expression because we need to let all ideas do battle within the open and neutral marketplace of ideas. By contrast, those who support cancellation tend to adopt the rhetoric of power. It's this idea that the marketplace of ideas isn't neutral, right? It's infected by an imbalance of power. So these sorts of appeals to high-minded free speech principles often act as cover for those who benefit from that imbalance. So on the one hand, you have this conception of an even-handed marketplace of ideas that works efficiently to uncover truth. And on the other hand, you have a conception of an inherently skewed marketplace for which the recent spate of cancellations is a necessary corrective. Now, my purpose here isn't to take any particular side in this cancel culture debate, but I do want to touch briefly on the question of how we might collectively approach this issue and work towards its resolution. So first, it's most important to recognize that this is not a simple binary question of whether cancellation is a good or bad thing. Rather, the question is how we should calibrate public discourse to achieve the best balance between the free speech values on both sides of the equation. Because cancellation can both advance free speech values and limit them, this is a complex and nuanced issue, and reaching a sensible balance requires a sort of measured and holistic perspective, one that emphasizes proportionality. So it requires this collective determination of when and to what extent social shaming in response to actions or viewpoints is justified and desirable. And practically speaking, this determination might rest on a wide variety of factors. So for example, is the cancellation based on the person's association with a particular viewpoint, as opposed to, say, their association with objectively bad past conduct? What is the type and degree of the sanction imposed on the offender? So is it mere social shaming, or is it something more concrete, like loss of employment? Is the sanction proportional to the reprehensibility of the offense or viewpoint in question? What is the nature of the relationship between the offender and the party imposing sanctions? And I'm happy to delve into these inquiries in more detail in the Q&A. Second, I think the resolution of this debate ultimately rests on a broad and open-ended cultural conversation about our own free speech values. But because this is an issue that largely resides outside of the realm of government regulation, there are really few doctrinal boundaries. So in the end, it's really up to us to collectively determine what sort of public discourse we want to have and to construct and preserve this discourse through the establishment of appropriate social norms. And in the United States, this is all indicative of a broad shift within our free speech culture. So traditionally, debates regarding free speech have revolved around the First Amendment, which limits government regulation of speech. But as public discourse has increasingly been dominated by private speech platforms like Twitter and Facebook and Instagram, First Amendment doctrine has grown increasingly irrelevant in shaping the future contours of public discourse, as fear of government censorship has given way to fear of private censorship. So really, the future of public discourse increasingly lies in the free speech culture that we, as participants in the marketplace of ideas, collectively choose for ourselves, right? So it's a culture derived not from doctrinal analysis, but rather through a broad social conversation regarding these free speech values. So maybe the best way to approach the cancel culture debate is simply to work towards building a healthier national and global conversation regarding the issue, one that recognizes proportionality and nuance and balance in evaluating the issue rather than political side taking. As we've seen in history, political valences regarding certain issues can shift rapidly, right? So today's cancelers may become tomorrow's canceled and vice versa. But it remains to be seen if we can break the highly polarized nature of our current public discourse in favor of this kind of measured cultural conversation, one that really recognizes and seeks to calibrate the free speech values on both sides of the equation. So I'll stop there. Thanks so much, and I look forward to your questions and comments.
All right, excellent. Very, very interesting and thought-provocative. We have one more paper today, Tatiana Barandova, and she will be presenting us a perspective on Russia, in particular, during the COVID period and migrants' rights and verbal official discourse. So, Tatiana? If you're with us.
Could you hear me, colleagues?
Yes.
Because yeah, okay, but I unfortunately I can't switch on the video preview because it seems it's not working on my laptop. Sorry. If it is okay, I will try to talk just orally without presenting my presentation. If you will wish, I will send it later for those who will request it. Is it okay? Because it's just some kind of technical. Okay.
Oscar, can you correct the technical difficulty, or should we just go ahead?
Okay.
No.
Sorry.
No, maybe it's a question of the Wi-Fi, or it's a question of the preferences of the navigator.
No, I think it's just a question of some kind of lack of technical equipment of my laptop for exactly this program. If I remember, it was nearby the same situation last year, so at least you can hear me, and it is already better.
Yes, that's good news, and the ideas are where I'm sure the actual depth is. So, Tatiana, if you take 15 minutes for opening comments, and then we'll have a discussion.
Okay. Probably I will even use a little bit less than 15 minutes, but who knows? Sometimes I can talk even longer without presentation. Well, actually, I didn't manage to make a really full scale review of the topic I was announcing, and the topic was announced. Right, if you can see, it was announced as a representation of migrants' rights and visual and verbal official discourse in digital context of COVID period in Russia. And actually, when I started to work with these issues, I found that it is not so easy to cover exactly both dimensions in such a small report. So I was just focusing on mostly on some kind of major points or most poignant points which were represented partly in an official discourse, mostly verbal, because for visual communication I had to provide you exactly the picture. So I will just skip these few slides and will not talk about visual too much. We just will stress some main findings or main ideas. And here, starting with, I would like to mention that migration in Russia, or migration to Russia, is a quite complex phenomena, as always in a global scale, of course. But we also have a very problematic situation, mostly with not only external but with internal migration flows, which are really totally unfixable at the moment and uncalculated, and no any kind of official statistic we can find. It is also connected with a quite bad situation with statistical services in Russia. So I may say a few words only, not with basic on statistical and some kind of quantitative data, but mainly with some kind of qualitative and expert views, expert points. And labor migrants, first of all, labor migrants, we are quite a big amount of labor force in contemporaries, at least at the beginning of the pandemic situation. but still now I think also because not too much, maybe no more than few hundred thousands migrants actually left the country, but later on majority of them actually had to return back because situation with especially it is connected with the situation with donor countries. Mostly provided huge migrant flows from Central Asian ex-Soviet Union republics. First of all, Uzbek, Tajik, Kyrgyz republics, and Ukraine. Ukraine also provided a huge flows of refugees connected with the war on the Donbass, and some political situations happened 5-6 years ago. And numbers of labor migrants a year ago, when all this situation started, were calculated by experts in approximately 13 of 12 millions. And it was actually even more than 10% of working age and ability population of Russian, according to Rosstat, Russian statistical agency. And besides with external and internal flows, which are of course providing quite different quality, so to say, in commas, of course, quality of migrant flows and different niche for migrants. We also have quite huge, as I already mentioned, quite huge problems with, maybe not problems, but issues connected with, so to say, officially registered or legal, according to Russian course, and non-registered or illegal, according to Russian discourse, migrants, those which are also quite problematic issues. And previously, with some of my colleagues and ex-students, we were following these migration policy changes starting from the end of 19th, and we saw that issues of non-registering or so to say illegal migration are becoming the most xenophobic, if it is possible to say this word, most alarmistic providers of most alarmistic discourse during whole post-Soviet period, starting from the beginning of 80s, after the collapse of the Soviet Union. So this situation, of course, could not be changed just during this last 1.5 years, when we all of us, or all society, were forced to in a quite total manner, was forced to join this digital, so to say, digital era. And according to also unstatistically proved expert, but experts' opinions, digital gaps are also quite strong in such a huge country as Russia, with many regions having different conditions in not only in technical but in any other spheres. So a majority of even officially registered migrants, labor migrants, especially from Central Asia, are working on a, so to say, basis of outstaffing. So outstaffing conditions when they are working for officially for business for one company or firm, but being registered officially in absolutely another, and due to legal or regulative frames of having the permission patent for having job, for implementing job in Russia. So in general, still even with some more slowly changes undertaken by the creation of strategy, migration strategy of Russia Federation up to the actually last 2025. our migration policy is still over-regulated and might be even called restrictive, having a restrictive character, and it's also some kind of important factor when we are coming to analysis of the discourses. Discursive instruments, I think I will not stay longer on this slide. I have prepared for just describing these discursive instruments which we are actually using, especially it's a critical discourse analysis by, I use the Vodek, Ruth Vodek, little bit corrected by my little bit edit or models for analysis of discourse. And of course, the main discursive strategies usually undertaken by at least by media, but not only, also by officials, are distinguishing in some way in accordance to which kind of migrants group, high qualified or low qualified workers are becoming these objects. And of course, the most problematic problem is the dehumanization, but now I can't say that we can find some too strong right wing, so to say, right-wing populist opinions coming from the Russian political officials, and especially on a high level. They are not distinguishing too much, migrants groups at the moment, and especially when we are coming to this medical support, etc. Officially, there is no too much of such kind of dehumanization strategies, but some metaphoric labeling, for example, no facing, if it's possible to translate it directly, so to leave people without kind of these personalities, let's say, depersonalization, and of course a lot of stereotypes, and these stereotypes are not changing too much if to compare with the previous period, and also when we were working with analyzing the press, media and TV, they are not changing too much if we are just working on the empirical data of social networks at the moment. And of course, the most stereotypes of migration and migrants are connected at the moment with the people from more poor countries like Central Asian, and if we are talking about internal, with people from Caucasus territories. Okay, I will skip this. Yeah. This visual, sorry, here should be visual, some kind of previously identified discourse. I can't show them, so I will come. I have 5 minutes, no more. Oh, it's already, so it's too short time for me. So coming to some fundings of this research, quite pilot research I managed to complete during the last half a year, and official and media discourse actually during the COVID period are not distinguishing too much migrants group, but they are seeing them, they are considering them as having a kind of special needs or recognition of special needs, even in a situation when migrants themselves are having, so to say, no voice too much, and not presented in a media discourse from the first phase, so to say. So they mostly presented or represented by NGOs and by official ombuds institutions. Not in all regions. We have by now ombuds institutions, state human rights protection institutions in each region of Russia. Not in all. They are mentioned in the special or annual reports from last year, also devoted to COVID situation everywhere. so we are presented but not represented by themselves. We're represented by some kind of mediators. Sorry. As for media discourse, which is not too much connected with official, of course, we can see much more xenophobic and stereotypic representations, especially when we are talking about visualization trends of migrants. But these trends differ if we are analyzing national or regional or local media or international, as I mentioned, some kind of social networks. But I wasn't working too much with this data by now. I'm just going to continue with this. So they are reflecting some kind of conflicting discourses. These kind of discourses are conflicting each other, and it varies from region to region and depends from the internal situation, both social, ethnic, national, etc., religious, and professional in each region of Russia. Of course, probably the most I may say more tolerate discourse exist in big cities at the moment, but at the same time it also depends about what kind of ethnic groups of migrants we are talking about, and analyzing this representation. So the most, of course, if we will watch more precise on the discourses about human rights, migrant rights, we can find three major blocks of topics. First of all, of course, economical and welfare surviving, and of course, it was connected with all restriction how to say. With all restrictions, regulatory, etc., which were introduced in the end of March, beginning of April 2020, of course, all economic sectors were suffered. First of all, if we are not talking about IT, probably banking and some other educational, etc. Some kind of budget funded.
Tatiana, would you repeat that last part? I didn't hear it. Maybe others didn't. You could just repeat the last sentence.
The last sentence, okay. I was talking about that all economic sectors were suffered from restrictions introduced in the end of March, beginning of April 2020, last year 2020. Besides probably IT and budget, so to say, budget spheres like education, etc. So the currently crisis, of course, was also was poignant with currency, Russian national currency ruble falling down in line with the oil prices, and it was some kind of interconnected in temporal frames. So and majority of migrants, especially who were coming for earning this money, these salaries in rubles, they also suffering like twice in a double way. And but I had to say that no official deportation were decided to provide from the government. So we had some kind of official government support for migrants. They were allowed not to use with official permissions for stay, like patents, etc., and we were allowed to stay as long as the situation will be closed. But at the same time, it was organized campaign for assistance, so to say, for assistance for return, with quite a lot of problems with transportation of those who wanted to leave the country, and violations of rights was also reflected in the media and in official discourses, and especially in the reports of human rights organizations and like a Memorial and the Moscow Office of Human Rights. The alarmist and xenophobic discourse was rising at the very beginning because it was expected the growth of criminalization, but it wasn't actually in a half-year perspective on the first wave. It was not it wasn't supported by the official statistics. The crime was even decreased during the 2020 in general. The second big point or big sphere was of problems was the physical survival and medicine access. Of course, I think it is connected with all social and medical rights of migrants. Just because this medical service are supposed to be provided, was taken under the state control and was expected to be provided, and actually in Russia for all migrants, not only during the COVID, in accordance with official policy, medical policy and medical insurance. Of course, even legally stayed migrants are not all, quite a lot of them are not having this kind of document, and by now vaccination is also based on these policies, and no any official statistics, of course, again we have about this situation, and no official statistic about the level of COVID cases generally in migrant spheres are available and exist. And the last point I'm going to finish. Last point is a human rights protection discourse. I mentioned where released several reports, not only by official ombudsmen but also by big human rights organizations. The most problematic issue was connected with the lack of all rights protection for those who were staying in the so-called centers of temporary stay of foreign citizens during the pandemic time. These centers are working for example, like a detention camps, for those who are expecting the deportation, etc., due to court verdicts or other official. So this was a really big campaign of releasing these kind of migrants in the very beginning, and by now, exactly these days, I'm still not able to analyze it fully, but by now we are also probably will have some kind of new portion of violation connected with the border crossing rules introduced from July. They should be introduced from 1st of September for it is already the third wave for all travelers and migrants, of course, coming from the new independent states, territories, via airports, first of all, and they have to provide QR code for vaccinations or some kind of official documents about recovering or having some antibodies. So this is a very new. I just fixed in the last slide. It is just under the process of introducing this new norm, these new regulations, and I can't say more about this, but I just expect that it will be kind of new version, exactly this, more connected with digital tools for violating rights. That's all by now. Sorry, I took a little bit more, 5 minutes more, sorry.
Okay, thank you so much. Thank you. That's another unique perspective. And then, Oscar, we have a discussant, right? We've only got 15 minutes left, so maybe some quick comments. I don't know if hopefully we'll have some time for questions as well.
Yeah, well, Jack cannot attend this meeting. I will do the function as discussant. I have some questions for each speaker. The first one for William. Nowadays, this question of the governmental speech is a very interesting point in Europe. For example, with the situation of Hungary and Poland, with against the promotion of homosexuality in schools. For example, now European Union is going to punish Poland and Hungary for this question of the government speech against the promotion of homosexuality. Okay, briefly, I am going to explain the situation in Spain, and first I want to ask the question. My question is the curricula, the educative programs, part of the governmental speech? Because in the case of Spain, any government makes a new program of education, and we have the right parties who make a program of education with compulsory religion and with certain topics, and the progressive parties come to power and consider religion less important, and then, for example, appears a course like education for citizenship, that is education in human rights, but the right people is against education for human rights because consider this is indoctrination, and this is okay. And then nowadays in Spain there is a great debate if the education of the people corresponds to the children and to the teenagers, corresponds to the parents or to the state. And this is my question for William. I ask all the questions and then all the answers. For David is very interesting, the cancel culture. I have an article on political correctness, very interesting topic. Okay, my approach is depend on how, and I think this moderate approach to cancel culture and political correctness is the interesting approach. For example, we have the case of a world-known designer who was fired because he made a statement drunk against with anti-Semitic statements and very anti-Semitic statements, and he was fired because in a private occasion, in a private circumstances, he made some statements. He was recorded with a phone. Okay, this is part of the cancel culture. Now, in the ceremony of Japan, the director of the ceremony of Japan was fired because he has made some statements, anti-Semitic statements. Okay, my question for David is, there are some limits to the cancel culture, and how we can find these limits, how we can search for these limits. And finally, for Tatiana, you talk about the situation as immigrant in Russia. My speech the other day was about Russia and China free speech, or how is the approach to free speech in China and Russia. And in Russia, there is a fight against extremism. There is a strict view to the fight against extremism, against the opposition. My question for Tatiana is, in Russia, there is an extreme right speech against immigration, or there is a government speech against immigration, there is a popular view against immigrants, or they are conceived in a positive way, they are conceived in a more view according to human rights, or there is a part of the society that are against immigration, because in other societies in Europe, there is a speech against immigrants and there is a speech against human rights. Okay, thank you very much. These are my questions.
Okay, so I guess I should start, Alex?
Yeah, that would be great. Yeah, let's do it in the order that people spoke.
Sure. So let me answer Oscar's questions in the order in which he asked them. With regard to the status of these no promotion of homosexuality laws, I think it would be clear that those laws would constitute what we call in America state action that would be subject to the requirements of the Constitution, like the 14th Amendment. Now, there's a twist here, because teachers have First Amendment rights also, and those rights are particularly important because of the status of academic freedom. So if teachers themselves were saying certain things in the classroom, then there might be an academic freedom argument that's based in the First Amendment. But if the state is mandating that certain things be said, then that would clearly be subject to the Equal Protection Clause. And for reasons I gave in my talk, I don't think the state should be thought of as expressing First Amendment rights itself when it required these messages to be made. Now, with regard to Poland and Hungary and the penalization of those countries by the EU, I think that's a fascinating question because because it illustrates the difference between how Americans think about free speech and how Europeans think about free speech. Because frankly, the idea that it would be appropriate to sanction a government or an individual for speaking in certain ways about racial or ethnic minorities, it's a very difficult understanding for Americans to have as a matter of free speech law, which is why I think I immediately talked about equal protection law instead. But the idea that private speakers or the government are somehow limited in their ability to speak about race or ethnicity or sexuality, it's a hard argument to make in the United States because of our very different First Amendment tradition, or free speech tradition. Finally, on the indoctrination point, there is a debate that Alex and David will know about in the United States currently about so-called critical race theory and the attempts by school boards to have teachers talk about the history of racism in the United States. That is seen by opponents as indoctrinating students. And I think there is no neutral way to distinguish between indoctrination on the one hand and simply inculcating public values on the other. Because what one person thinks are inculcating public values, another person thinks are indoctrination. And of course, they really are essentially the same thing. So that issue comes up in the United States a lot, especially because there's local control of school curricula, and the indoctrination charge is very, very often brought up by opponents. And I'll stop at that.
So Oscar, to answer your question, and that really is the big question, right, is how do we draw limits here? What should the boundaries be when we talk about, cancel culture? When is sort of social shaming appropriate? When is it not? And really, it's an answer that's impossible to answer it's a question that's impossible to answer in the abstract. We're really operating based again on cultural consensus more than anything. It's kind of what kind of free speech culture do we want to have? What kind of public discourse do we want to have? And it's kind of this collective decision-making process. And so to look at it more pragmatically, I think things that we ought to look at, because again, I think it's a nuanced issue where we have to think about questions of proportionality. So some of those factors that I mentioned in my talk. So for example, sanctioning someone for their viewpoints, solely for their viewpoint, rather than for, say, past objectively bad conduct or something like that. Someone is canceled because it comes out that they were embezzling money. Well, I think that doesn't have as much of an effect on free speech values as opposed to, of course, canceling someone because they share a view that people disagree with. So that's one factor, I think. One, of course, would be the severity and the nature of the sanctions, right? I think to the extent that we're talking about social shaming in the abstract, just critique and condemnation, I mean, that's counter speech, right? You can't be expected to feel insulated from social critique if you make a statement. So that to me is not, I think in the abstract, is not particularly problematic in and of itself. Of course, when it comes to things like, well, then there's loss of employment and deplatforming and things like that, I think it tends to get a little bit more problematic because you're saying now, you can expect to be criticized, you can expect to be condemned if you share a viewpoint with which other people disagree, but perhaps that's a more significant price to pay, and that may have a much bigger chilling effect, of course, if you're dealing with concrete sanctions like that. On the broad sense of proportionality, and again, this is all kind of cultural conversation. This is not doctrine. So to what extent do we say, the punishment fits the crime, right? And here the crime is, certain viewpoints are more reprehensible than others. I think we can all recognize that, right? And so, and again, it sounds strange to talk about this in the free speech context, but we're not talking about constitutional norms like content neutrality here. We're talking about private norms. So again, as we kind of as a collective, what are the values? What are the norms that we're going to kind of adopt in operating our public discourse? At what point do we say, everybody, again, as I said, everyone cancels. Everyone, to a certain extent, will say, okay, this is too far. But I think we have to have a conversation about proportionality, and we should decide, when do we say we've calibrated it the right way, where on the one hand we sort of have a sense of proportionality, but we have a sense of proportionality that really brings the values on both sides of the debate sort of at a good balance. And of course, wrapped up in all this is the idea that on the one hand you have the chilling effects of speakers, but on the other hand you also have the associational rights of those who may not want to be associated with that speaker anymore, right? So to a certain extent, you say even if it's chilling, the organization should be free to say we don't want to associate with someone that has these views, right? Which is why this is such a complex issue. We're not in the realm of kind of doctrine and sort of content neutrality. We're in the realm of sort of how do we want to design our own public discourse? And it's kind of just up to us in the context of this, again, kind of broad cultural conversation. And to be clear, this is just one of the issues that comes up with the cancel culture debate. There's all sorts of other issues that come up, and some which may come out in the examples that you raised. So there are also privacy-based concerns when it comes to the cancel culture debate. So to what extent should one be able to say, this is something that happened, I want to be able to bury my past, right? I want to be able to not have something that happened a long time ago in my past come up, which is a kind of independent issue that comes up in this. So it's a complicated issue. I focus sort of on this free speech aspects, which has all these kinds of factors, but I think there are lots of other issues that are tied up in that as well.
Okay. So since it's my time to. Okay,
yes, I'm sorry. I got disconnected, and David, I didn't get the end of your answer. I somehow got disconnected. I'm sorry. Go ahead, Tatiana, and then I'll have a couple more questions, and then let's end this session because we're really at the end of our time, and I know people have other obligations.
Okay. Actually, this is quite interesting question about what our officials at the moment are talking more about extremism prevention, so to say, or struggle against extremism and etc., or terrorism, or considering these migrants as a human rights. I have to say that it's actually no that at the moment, as I especially I didn't investigate, didn't research exactly this focus on extremism discourse, because it's quite special discourse. It needs more thin instruments, so to say, to deal with this. But I have to say that at the moment, according to my kind of intuitive following the situation, we have such high level of authoritarian trends and patterns in the political regime in Russia that society is totally an enemy, and it's not not able, to my mind, to produce already kind of human rights protective discourse in general, or even not to produce, even not to request for it. It's just to my mind, it's quite indifferent and suffering from these social and economic collapse quite strongly. Not only migrants, or not only migrants of low qualification, but also in the cultural circles, for example, with high qualified specialists are also, or sports industries, they are also quite under problematic situation. And I think it's globally, maybe not too much in developed countries, but anyway. And I have to say that official discourse about extremism previously was also quite specific, and it was focusing mostly on special territories of Russian Federation, special regions of Russian Federations, mostly connected with the around the Caucasus territories, around the Chechnya, Dagestan, etc. Yeah, it was they were represented as a kind of producers of this danger for society. But then we met in general with much more real and close to each other and unfightable at the very beginning danger, like so public danger as a COVID. I think this kind of discourse just somehow it exists, but not on the first positions probably in our official rhetorics, because now I think we are more focusing on the foreign, so to say, foreign danger, foreign kind of, especially some kind of external enemy, not trying already to find. We'll see what will happen during the elections, but at the moment it's looking like with society in enemy and I mean anomia, I mean in Russian, and public discourse is also somehow, maybe just because I was making my research during the mostly end of spring and summertime, but it's just kind of intuitive. I didn't I just have to stress again that I didn't focus my research exactly on this extremist part of this discourse against migrants. What I found, and even both in media, it was some kind of understanding of common problems, social problems, first of all, for all society. And at the very beginning, it was kind of alarmist discourse, expecting criminal. But as I already told, that by official statistics, our Interior Ministry of Interior Affairs just reported that it was decreased quite a lot, quite high percentage of decreasing of a criminal during the last year. So. But I have to focus on it when I will write the paper. I may take this if you wish, Oscar, because I think it's important. Yeah. Thank you for the question.
Thank you so much. I'm going to be very brief because I know we're over time, but just things to think about. And my questions are so. I mean, if people want to answer it, they're welcome to. But let me just start. Bill, I wonder whether you've looked at the 13th Amendment standpoint with the Confederate flag. You're focusing on the equal protection, which I think is absolutely critical with animus. But I also think the animus point that you point out could be relevant also for under the 13th Amendment. Maybe I'm mistaken, but it's worth just taking a look at. The other thing is I really like the way that you presented that diagram, Bill. It would be great in the final paper, and I assume you're going to do this, but just to make certain, just to hit the point home, to integrate your extremely important research on animus further enrich the ideas that you've already developed. The final thing to Bill Araiza is I wonder about the extent that this deals with academic freedom and academic free speech. So that's just those are the points for Bill Araiza. David, also, as I said, extremely important paper, as I think all of these are. It was a real pleasure for me to listen to them, and though our numbers on this call are small, it's so great to be able to just share ideas. And I just wonder, David, I did not hear in my reading of the initial paper that you sent, the shorter paper, is to look at cancel culture in the legal academy, or in the academy just generally, not just in the legal academy, but in the academy, because what you were saying about critical race theory at the school district level, I think is actually coming out in the academic world as well, where critical race theory is not a perspective that's legitimate and important for us to deal with, but the perspective. And if you take anything against it, then you're in some way in league with people who you might completely disagree with, but you might have a very different perspective on in terms of subordination, and just that it's perspectival, and that we're seeing more and more an orthodoxy, I think, even in the academy, with administrators being very concerned to not disagree with certain points of view. The other thing, and I think this is a big point, and it's a completely separate one than the first one I said, is to what extent can regulations even come into play here, or would they be completely chilling of speech? And are we really talking about incentivizing through discourse analysis of balance? And the final one is, how does balance work? And, you know, of course, Justice Breyer's model on this, there's a European model on balancing. I'd be glad to help with if you need to locate that. And then, of course, I've worked out a balancing model myself in my most recent book, Free Speech and the Balance. Tatiana, also a very important paper. I'm very interested to learn the extent to which migratory policy in Russia is being driven almost exclusively by the presidency and or by the executive branch, and the extent to which autocracy has become so dominant that the legislative branch has any role or no role, some role. Anyway, I would love to hear about that. So maybe if people have very brief answers, and then we're going to end the session.
So I'll just start really quickly and agree with everything you said about the 13th Amendment and integrating animus, Alex, and academic freedom. Those are all really excellent points. So thank you for those suggestions.
Yeah, and Alex, on your first point on sort of cancel culture within the academy, I mean, I think academic norms are sort of specialized norms, right? They're in a way they're very different, right? So, you know, there is a sense that, you know, when we talk about free speech theories and we talk about the marketplace of ideas and the pursuit of truth, those have been criticized as sort of theories, but it's also sort of recognized, I think, that it's within the academic sphere that those kind of operate, you know, most, I would say, efficiently, and that where there's sort of strong norms of that. So I think the academy question is, you could view that as a sort of distinct question, because there is far more of a norm, of course, within the academy of open debate over anything, you know, the tenure system and all sorts of things like that. So I think there is, so I do think what you're recognizing that, you know, the broad cancel culture debate in the community at large may be sort of distinguished from, you know, specialized kind of communities like the academic community to a certain extent. I think on the question of regulation, I do think that regulation could be relevant in some aspects of the debate, but my sense is that it's largely external to the heart of the debate, which is really just a question of public values, right? Because who, you know, in the end, if people want to stop associating with somebody because of, you know, because this, if a private employer wants to stop associating with somebody, there's not much that can be done to prevent that, right? And the question is, we should, you know, what are the norms that we want to kind of develop as a society of, you know, when, you know, of again, proportionality and kind of sort of trying to balance those free speech values on both sides of the debate. And so, Alex, I forgot the third point. Can you remind me what your third point was? I think you had a third one.
Yes, I was just saying that I'd like to hear a worked out methodology for how to balance, to engage.
Yeah, and I think just very briefly, it's I don't know if there can be much of a worked out methodology apart from the kinds of questions that I raised, which is, you know, is this kind of based on someone's viewpoint? Is it based on someone's past, you know, objectively bad actions? You know, how reprehensible is, you know, the viewpoint or the conduct, and how, you know, how much proportionality is it? There's, I think it's hard to work out a methodology because this is not going to be courts resolving cases, right? It's going to be us kind of society coming together and trying to develop these kinds of norms. And it'll be messy, and there's not going to be any guiding force necessarily. There may be influential voices on one side or the other, but Alex, as you well know, when it comes to this kind of proportionality, it to me is more about the process, right? It's more about the conversation, I think, than perhaps, because I think it's going to be difficult to come up with. We all agree that these are the 4 factors you have to look at, and here's exactly how you weigh them.
Okay. Alexander? I just checking. Do you hear, colleagues, do you hear me again?
Yes, yeah, we hear you.
Okay, Alexander, I'm really sorry. I was just looking on my cat at the moment. She was asking for food, and I didn't catch a question. Could you please just repeat it in a short, because
Yes,
sorry.
So to what extent are these decisions about migrants being made exclusively by the executive department and branch of the government, and to what extent is the legislative branch involved in an independent manner?
Oof. Well, in what extent? Honestly, I don't have the answer on this question at the moment. I think I have to think more, because what I was starting to do, just like a pilot, just a pilot version, and maybe I will be able to include more, also both in methodologically and also in kind of more wide observation, also more data involved in a written report. Because I'm sorry, I think I can't answer right now on this question. I have to think more. It's true. It was just.
That's the story of all of our academic lives, isn't it? That we need research to find out more details in order to improve.
Yeah, sure. New thoughts are just appearing in a very, very moment, and so many of them. So losing in my reflections.
That's the beauty of knowledge, isn't it? That the old saying, "The more I know, how little that I know."
That's true.
Thank you so much. This was a fascinating section. I am so grateful to all of you for participating and for enjoying part of our summer together in our intellectual pursuits. And I look forward to seeing you all very soon. Oscar, do you have any final thoughts?
No, yes. Well, it was a very interesting session. Thank you very much for the participation. It was a good discussion. I hope the papers will be, the deadline for the papers, for the final papers, will be on the 1st of September or the end of August. And I hope the publication of all the papers will be a good publication, and we have a publication in the same level of the seminars.
And Oscar, you're in negotiations with the publisher now, as I recall, right?
Yeah.